Hello and welcome to Rise High YouTube channel. My name is Abdul Shah, and in today's video, we are going to discuss a very interesting article under the deep analysis section. The article somewhere addresses the core misconception which most of the people in this country have. Is judicial holiday that necessary? The article states why judicial holiday unnecessary. In the article, I have listed all the important facts which are bare minimum required for a aspirant to know. And from all those points, the Rice IS team has made a constructive article for you, which will become a one-stop solution if any kind of question is been asked from this concept. The article of that title is Debate over Judicial Holiday and the Unseen Burden of the Judiciary. Now, before starting any topic, we should have a clear idea about the topic. So to get a clear idea, we must first discuss a model question. Model question is the discourse of judicial holiday often overlook the invisible intellectual labor involved in adjudication, critically analyze the necessity of judicial holiday in India while examining the reforms required to improve judicial efficiency and access to justice. 15 marks GS2 Polity. Once done, now let's directly jump into the core idea of the topic. The core idea can be understood from the very introduction, where the so-called going concern over mounting judicial pendency restarts a debate on judicial holiday, which somewhere pointing out to be a critical question. The question is, should court, to be very specific, higher courts, not the high court, higher courts, vacation be viewed as an institutional inefficiency or as an essential working period that upholds the quality and independence of justice delivery? Keeping the core idea in mind that is it necessary or is it a colonial idea which we are carrying forward? For that to decide, first we have to address the very idea of holiday. The very idea of holiday for Supreme Court comes from Article 145, summer vacation and winter vacation, as well as its counterpart articles in High Court, for High Court, where under 145 we get to see it empowers Supreme Court to frame its own rules regarding practice and procedures. Judicial vacations are governed through court's rule and administrative arrangement framed under the constitutional authority. And at last, it reflects the principle of judicial independence, where judiciary is able to frame its own rules and regulation to govern itself, allowing the judiciary to manage its internal functioning without executive interference. This is the core idea from which the judiciary, the higher courts of our country, get holidays. Now, the important part. As we have discussed, what is the core debate here? The core debate is distributed under criticism and counter view in this. Where at one place we get to see over 5 crores of pending case in India, where courts are sitting fewer compared to other public institution, other counterparts in the other organs of the democracy. And delay justice again affects the citizen and the business, which directly or indirectly affect the economy and the culture of the society. But the counter view, which we are going to see elaborately in our content, the counter view provides judicial holidays are largely working period, not a leisure period for the judges. Judges use this recess for judgment writing, research case preparation, clearing all the reserved matters that is pending before the Lordship Court. Now, once we have seen the core debate, let's now dive into the significance why judicial holiday matters. Then we'll see its importance and counter perspective. First would be it somewhere ensures the quality of justice, where the judgment affects day-to-day lives, people's life of liberty, property, governance, and economic right. Therefore, a critical thinking is required. Non-sitting period also enables careful reasoning, the back idea, the constitutional scrutiny, and the precedent analysis, where the court is not sitting but the court is actually working. Second, it allows the judges to cope up with the changing complex litigation, where increasing case involve AI, cybercrime, environmental law, constitutional governance, and global commerce, which is changing day by day, which requires extensive research beyond regular courtroom, which is again re-emphasizing upon the fact why it is the holiday is important. The next, it ensures judicial independence, as we have seen in Article 145. Next, it prevents judicial burndown, where judicial work involves constant interpretation, constant critical thinking, constant doing intellectual work, where reasoning and balancing complex lifestyle is allowed to sustain a efficient mental and effective mental space, equality education. The last, institutional productivity, where we see there is a curve, upward curve. Post that period, the spike period, the productivity get reduced. Where the judiciary is in working space, it reaches the top upper level of the cycle, and this phase is been cushioned by a holiday, where a slowdown process is seen. Post the holiday, the judiciary or the judicial process again rises to maintain its efficiency. So, the vacation allows the judges to have their leisure time, to spend time with their families, and to think about those judgment which has been reserved by them, as it requires more time, more critical thinking. Once we have discussed the importance, now let's see the arguments in favor of the holiday. The first would be judicial work extends beyond courtroom. Even if the court is not sitting in under Article 145 during this vacation period, the judge and its clericals are constantly at work. Working window, it is a working window, not a vacation, which is again re-emphasizing the same point. High intellectual demand. The work itself demands to be intellectually reasoned and highly productive. In that scenario, these kind of holidays are very much required. And the second last is public service sacrifice. We all know the judges in our high courts have somewhere sacrificed their high paying life for giving service to the nation. The article quotes that the counterpart, the lawyers earn more than double than the judges which they get from the Consolidated Fund of India. But just to repay or to recognize their service towards the country, it is a part where we give them a lucrative legal practice space where they can explore their ideas and have a leisure time with their family. And at last, when the court are open, we will see multiple case studies where a judge always compromises its personal and family space. It costs him opportunity cost. So this vacation somewhere plays an important role, where the justice is able to justify or to negate those time which it has not given to its personal space or its family. But keeping all those things aside, if we now look the arguments against the proposition, we will see some different issue. Even after providing holiday, even after providing them a period where they can spend leisure time, the efficiency of the court is not being seen through the pendency cases. As we were seeing, more than 5 crore cases are pending. These off days delays the public trust of justice delivery. It also directly affects the sitting days a court has, whereas it direct proportionality towards delivery of justice. The access of justice, we know only the important to important facts or the cases are listed during this period. So we get to see a equity, a non-equity in place, court closures, delay of urgent matters, economic cost is attached to it, where delay of the civil cases and at times criminal cases have a huge litigation cost and as well as a development cost. And at last, the perception of public. Justice not only delivered but to be seen. That very notion is been disturbed through the idea of vacation. Now, before drawing a well balanced way forward, we should now see few case studies which the article mentions and global best practices so that we can give a better way forward. The first would be the idea of ex-CGI Justice D.Y. Chandrachud. Justice he authorized 600 plus judgment and sat on around double 1200 plus benches, which is an example of immense workload handled by the judges, which again solidify the fact they required a vacation. Justice H.R. Khanna, we see he was the lone descent of ADM Jabalpur, where he recognized the fact that this judgment will cost him his chief justiceship. In spite of the fact, he symbolized the judicial courage and constitutional morality, which was the descending judgment of ADM Jabalpur, but was emphasized onto KM Puttoswamy, K. Puttoswamy case, where we get to understand the real importance of Justice H.R. Khanna. Next, we get to see Justice Ruth, where we get to see Justice worked late night, exemplified the unseen labor of judging. And Lord Denning and V.R. Krishna Iyer were continued legal scholarship long after retirement also, and which illustrate a lifelong commitment towards jurisprudence, which this justice have towards the system, towards the fraternity. Now, let's now look at some best global practices in place so that we can draw a way forward. The first would be the United Kingdom, where its staggered vacation court remained functional year around. For United States, we see strong law clerks and research support team to judges for judges, so that on the idea of which we are arguing that they need holidays, they need vacations to do research, to add on to make themselves comfortable to new challenges. That work is done by a strong law clerks and research support. Third would be the example of Singapore, where we see advanced e-filing and digital case, which again addresses the 5 crores pending cases, speedy adjudicating of cases. In Australia, we see differentiated case management based on urgent and complexity, where the whole court is not going to vacation, but judges are going to vacation rotation wise, so that the court is again functional, as well as it is also addressing the stress condition of judges, the complex necessity of judges, and several jurisdiction vacating bench also ensures that it is feasible, uninterrupted access of justice. Now let's see what all way forward can be put in. The first would be increase the law clerk, judicial assistants and researchers, so that the idea of US and the system of US can be implemented in India. Second, filing of judicial vacancy expeditiously, so that the vacancy can be filled up and the court doesn't have to work late night because of lack of manpower. And last, improve court infrastructure and digital capacity, so that again the court is capable to handle extreme pressures. Process reform, where introducing staggered vacation like in Australia, expand vacation benches so that more benches and more cases can be heard during these vacations, and adopt AI assistant management, case management and document review, so again the process is speedy. And at last, if we see a structural reforms, we will get to see we should focus on more judges to population ratio, so that more judges are available in the courtroom. It should strengthen an alternative dispute resolution mechanism, so that the burden of court is reduced. It should modernize the courtrooms also, so that court can administer justice and deliver justice more accurately. Now, we are on the last part, the conclusion. The conclusion states, which will again somewhere represent my core idea. The core idea is, the real challenge is not whether a judge should have holidays, but how the judiciary balance equality adjudication with timely justice. The main bone of contention is not that whether the judges should have vacations or not. It should more emphasize upon the quality of justice, where even if the judges are going to vacation, it should ensure that the justice delivery system is not delayed. Judicial holidays should be viewed as an institutional necessity, while pendency must be addressed through systematic reforms rather than by treating vacation as a sole cause of delay. As we all know, any problem is not just because of a small effect, or it is because of multiple chains of effect that has happened. The same thing in this case also, pendency of case itself or vacation itself cannot justify and only justify the pendency in the courts. But we should ensure at the same point of time what is necessity for the judges. It should also complement or also is able to uphold the idea of equality in justice delivery. That is all from this discussion. I hope this discussion was indeed helpful for your preparation. And if it was indeed helpful for your preparation, I would like you to like this video and subscribe to RiceIS YouTube channel. And yes, if you are wondering from where I can get this detailed PDF, you can get this detailed PDF from RiceIS website. Thank you.